You had created a Reddit profile with the name Ladder. You made at least three thread posts on the site to include stating, "Man who loves to spread his hello, I'm in love with my with toys, fingers, hands, whatever." You also viewed and reposted two videos, including "My boyfriend had fun with Molly Little" and "Play with both tight."
This might be funny if it was not probably the most dangerous parole revocation hearing for the most dangerous felon chomo monster that we have ever covered. Now, if you're new to this channel, you might think this is clickbaity, but you are going to see with the receipts, with the proof, just how true of a statement this is. You see, his history dates back over 10 years. He was actually on parole when, in broad daylight, he attacked and full on essayed a woman in a parking lot. The DA actually argued with the judge to only sentence him to 2 years, and I will show you that proof. Now, he ended up getting a whopping 6 years, which, by the way, while in prison, he SA'd a female guard. Then, when released from prison, he started to stalk an employer. He put a tracking device on her app. He was sent back to prison on a 1 year technicality, and then released now again. He was stalking his new employer, full on stalking her. Now, what do they do? What does the prison in all of its wisdom do? They continue to give slap on the wrist sentence after slap on the wrist sentence. As a matter of fact, this is his third revocation hearing in fewer than 3 years. And I want you to know that while he is in prison waiting for this revocation hearing, we're about to find out, he continues to stalk his former employer, his former manager. The prisons can't even stop him from making phone calls and sending letters. It's the insanity of monsters like this being able to walk amongst us, creating new victims. The idea that the DAs will fight for them to have shorter sentences. It's mind-blowing. Now let's buckle up and watch the most insane parole revocation saga that we have ever seen. And I'm going to share all the insane details with you as we go. Now let's jump in.
Good morning, Mr. Oakes.
Morning.
Morning. Before we get started on anything, I know that you had checked, you wanted to waive your preliminary hearing. Because you don't have a criminal violation, I have to see you. So I can grant that waiver if you would like to. It's up to you, or we can move forward with the hearing today.
You just move forward with the hearing today.
Okay, PO divider for there. Okay, perfect. All right, so we'll get started then with your hearing. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's a preliminary hearing starting Oakes Allen, number 3255582. Today is December 9, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Alan Oakes, ALLEN, OAKES, number 325582.
Thank you. We have parole officer present. Can you please identify yourself?
Megan DeVilder, Hartford Special Management Unit.
Thank you. This is a preliminary hearing, which is the purpose of under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficient serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, means releasing and placing you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending for the proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything to say this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue a probable cause and severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I'll inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, no
Okay.
question.
You have important rights today, which I'm going to review with you. The rights to have an attorney present. Do you want to continue without counsel?
I do.
Okay, you have the right to receive the written notice of charges of violation. Did you receive the written notice?
I did.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
I do, yes.
Okay, so we'll now review the charge. State your false or bring against you. Any information underlying each charge. Computer Violet, please read the charges.
Charge number 1 under release direction, GPS, on 8/16/2024. You failed to charge your GPS unit as required, resulting in a battery shutdown beginning at 4:33 p.m. and ending at 8/17/2024 at 5:51 a.m. For approximately 12 hours, your whereabouts in the community were unknown. On 9/7/2024, you failed to charge your GPS unit as required, resulting in an approximate 3-hour shutdown from 12:27 p.m. to 3:34 p.m. Your whereabouts in the community were unknown at this time. On 9/8/2024, you failed to charge your GPS unit as required, resulting in an approximate 2-hour shutdown from 3:51 a.m. to 5:36 a.m. Your whereabouts in the community were unknown at this time. On 7/4/2025, you failed to charge your GPS unit as required, resulting in a shutdown from 3:29 a.m. to 10:05 a.m. Your whereabouts were unknown during this time. On 11/16/2025, you purposely cut the strap to your GPS unit at approximately 7:17 p.m. and removed it from your ankle. You left the GPS unit in the basement of the halfway house. Charge number 2, program participation. You were unsuccessfully discharged from CTPSB sex offender treatment due to a continued display of high-risk behaviors, stalking, harassing, that mirror previous behaviors. Charge number 3, under residence, on 11/16/2025, after removing your GPS unit, you exited the front door of a halfway house with no intention to return to your only parole-approved residence. At no time between 11/16/2025 and your remand date of 11/19/2025 did you return to this residence. Charge number 4, absconder. On 11/16/2025, after cutting your GPS unit strap, you intentionally walked out of your residence at approximately 7:17 p.m. At no point did you attempt to contact your supervising officer as you evaded your parole supervision. Your whereabouts were entirely unknown until you were located at Bradley International Airport by Connecticut State Police Troop W on 11/19/2025. Charge number 5, halfway house placement. On 8/6/2024, you were on a work pass from the halfway house and were due back by 5:22 a.m. You admitted that you deviated from the pass and went to the airport, which is a misuse of the pass system as you are only permitted to go to and from your employer. On 4/1/2025, you were issued a pass to accurate staffing from 10 a.m. to 1 p.m. and stated that you were there. A review of your GPS monitoring indicates that you never reported to that destination. This is a misuse of the pass system. On 6/16/2025, halfway house staff witnessed you smoking a marijuana joint on smoke break, which you admitted to. A search of your space yielded you to be in possession of marijuana. These actions violate the halfway house agreement as you are not to consume or possess marijuana at a halfway house. On 7/4/2025, you were directed by your supervising officer that you are not to get in a car with anyone other than an approved driver, as you are aware of in your halfway house agreement. A review of your GPS monitoring indicates that you were in a car on 7/4/2025, 7/6/2025, and 7/7/2025. At no time did you propose anyone to drive you, nor was anyone given permission to be an approved or authorized driver. On 7/8/2025, you admitted that you knowingly violated this rule and you received rides home from work. On 9/7/2025, when you returned to the halfway house from a work pass, you were found to be in possession of marijuana. At no time are you to consume or possess marijuana in a halfway house. On 11/14/2025, you were issued a common pass to attend religious services. At no time did you go to your destination, which you admitted to. This is a misuse of the pass system. Under charge number 6, enhanced internet and device monitoring. On 6/24/2024, you were found to be in possession of an unmonitored cell phone. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Sexual Behavior that you were using the computer at the halfway house, which is unmonitored. On 10/29/2025, you were found to be using an unmonitored computer at the halfway house. You knowingly use this unmonitored device to access prohibited sites and material to evade parole. Charge number 7 under problem sexual behavior treatment. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Sexual Behavior that you had been frequenting a dating website. Per your treatment agreement with the connection, you are not to access any dating sites without prior permission. On 9/12/2024, a review of your IPPC enhanced internet and device monitoring was conducted. Supervising officer reviewed over 374 pages of keystrokes. A significant number of these keystrokes were through the use of various end-to-end encrypted applications, including but not limited to Caption Call, Text Me Up, WhatsApp, Telos, Cloud SIM, Bumber, Incapation, iPlum, OpenPhone, BIP, Ring4, and Duo. In these applications, you're attempting to message, call, and or text random telephone numbers in sequential order. In many of these messages, you are identifying yourself as Brittany, attempting to make contact with a female. You admitted that you were hoping to get an answer and that you can't stop as you are trying to satisfy your needs. Excerpts from the numerous randomly attempted contacts include, "Hey, sorry to wake you. It's Brittany. Let me taste you. I'm so horny. I want to play with you. I'll pay you." You were soliciting acts and offering to pay between $50 upwards to $350. In addition, you inputted the following: young girls naked, young little girl 7-year-old girl tick, and little girl. You also used a web image downloader to create stimulating pictures of children that you saved to your phone. On 10/29/2025, you reported to have been using an unmonitored computer at the halfway house. You provided your supervising officer with login and your history was reviewed. Per your CTPSB treatment agreement, you are not to be communicating on social media or chat sites. You had created a Reddit profile with the name Ladder. You made at least 3 thread posts on the site to include stating, "Man who loves to spread his hello, I'm in love with my hole with toys, fingers, hands, whatever." You also viewed and reposted 2 videos, including "My boyfriend had fun with Molly Little" and "Play with both tight holes." At no time are you to view stimulating material on any electronic device. In addition, you were searching various platforms for your former supervisor. When questioned about this, you stated you wanted to learn more about her. You are not permitted to access social media platforms per your CTPSB agreement. And lastly, on 11/20/2025, the Center for the Treatment of Problem Sexual Behavior unsuccessfully discharged you from problem sexual behavior treatment based on the continued high-risk behavior that mirror your previous offenses.
Thank you. Could you just please read the evidence?
A, remand actual custody order. B, PCS conditions. C, parole violation notice. D, parole violation report. E, CTPSB offender treatment agreement. F, GPS agreements. G, misconducts, incident reports, disciplinary reports with supporting evidence to include GPS attendee monitoring, pictures, etc. H, CTPSB letter documenting unsuccessful discharge. I, police report and corresponding evidence. J, CHR email thread. K, Reddit printouts from 10/29/2025. And L, BOP decision information summary update.
Thank you. And the only thing I added was halfway house agreement that added that to exhibit F with the GPS agreement. Sir, did you receive notice of parole violation report, and those other documents that were just marked? And did you review those?
I did.
Okay, do you need to continue this hearing, to obtain any additional evidence?
No, I do not.
We have no witnesses today. So at this time, I'm gonna swear in, Peter DeViler as well as you, so that in the event you would like to speak, you may. Can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
I do.
Sir, that was for you too.
I'm sorry, I do. Yeah, I do as well.
Okay, so at this time, the state will have an opportunity, if you'd like to make a short statement and testify with respect to probable cause and three of the allegations you may at this time.
I don't have a statement at this time.
Okay, so it is now, your opportunity to respond for all violation charges against you. Remember that you may remain silent if you so choose. Would you like to respond to the charge at this time, sir?
Briefly,
Okay, go ahead.
you know, I mean, I take full responsibility here. I mean, I intentionally cut off my bracelet. You know, these things are something I've been dealing with my whole entire life. When will I get it? I don't know. I mean, there's no excuse. I'm not here to make excuse. I'm not here to fight. I did what I did. I face full responsibility for actions committed because I knew what I was doing. I knew what would happen when I did. It's just been a stressful time in my life. Things seem to always start off by going good. Then there's something that is in my mind with the anxiety that feels otherwise. And that is something that I must get under control, is to understand why I get anxious and why my depression always takes over, and me misreading into things throughout my life, or the behaviors that I display are from me being anxious for whatever reason. So it's time to stop avoiding and evading that part of my life and get it together. And that's what I plan to do for the next 10 months that I have. I've already made that decision myself.
Okay, well, I appreciate your statements today. So what I am going to do, is there anything from either other side before I announce my findings?
No,
No.
All right, so I'm going to announce my findings in regards to the charges. So regarding charge one, I do make a finding of probable cause GPS based on evidence and testimony presented in support of the violation, which is exhibits B, F, and G. Regarding charge two, I make a finding of probable cause program participation based on evidence and testimony presented in support of the violation, which is exhibits B, E, G, and H. Regarding charge condition 3, residents, I make a no finding of probable cause based on the charge not meeting the elements. On charge 4, I do make a finding of probable cause abstander based on evidence and testimony presented, exhibits B and G. Regarding charge 5, I make a finding of probable cause halfway house placement on all everything noted in the violation. This is based on evidence and testimony presented B, F, and G. Regarding charge 6, I make a finding of probable cause on enhanced internet and device monitoring based on evidence and testimony presented, exhibits B, E, and G. Regarding charge 7, I make a finding of probable cause problem sexual behavior treatment based on evidence and testimony presented in support of the violation, exhibits B, E, H, I, and G. I do find the act serious enough to warrant revocation or to be detained while you wait for your revocation hearing. At the rev hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or whether any sanctions should be imposed. So it's a technical violation. So we have 60 business days from your return to custody to schedule your hearing. So we will schedule that and you'll be notified of that date. Do you have any questions, sir?
I do not.
Okay, so that concludes your preliminary hearing. And we will see you shortly. Okay.
Okay, thank you. Thank you.
Peter DeViler, do you plan on participating at the rev hearing too?
Yes, I will be
Okay,
there.
so I will put you down for that as well. All right, so we're all set for today. Have a good day.
Thank you.
Thank
Take
you.
care.
You too.
So,
That revocation hearing happened December 9th of 2025. We are going to fast forward to January 30th, 2026 to now see the second hearing, the hearing where the board member will make the decision. The interviewer will make his decision. But before we see it, I just want to share all the information that we have so you can see the insanity of this case. Remember, he is facing a revocation after he is found cutting off his monitoring bracelet, after having a phone which he can have, after being found in the airport, God knows why, and after stalking his former manager, which is, by the way, one of the reasons that we are even here today. This is not the first time that he's done this. Why? How in the world they would even give him a job is just insane to begin with. But let's start here. It goes back all the way to 2014, not his first felony, because he was a felon when he committed this crime on parole. So a state employee was SA'd after leaving work. The State Department of Environmental and Health Protection is stepping up security. I love how they do this. They're such psychopaths. We're stepping up security. Coco's saying hi. As his at the headquarters in Hartford. Wait till you hear what they say afterwards. After a 24-year-old seasonal employee was SA'd while walking to her car after work Monday afternoon. She was SA'd in broad daylight by this monster. Okay. Police have arrested 26-year-old Alan Oakes, a convicted felon who had been on probation and lives in a halfway house on Collins Street in Hartford. He was charged with first-degree SA and second-degree breach of peace, enough to give him a 20-year sentence. Now, according to the incident report, Oakes had been smoking K2, a synthetic form of the devil's lettuce, aka Mojo, as the bus stop at Constitution Plaza when he began to wander through the downtown area around 2 p.m. on Monday. You can't make this up. Oakes told police that he sat down outside 10 Clinton Street, which one housed the Connecticut Department of Health Laboratory, now located in Rocky Hill. The victim, who was going to retrieve her car from a state employee lot on Capitol Avenue, had just finished her last day with DEEP on Elm Street and cut through the lab property on her way to the parking lot, according to the incident report. She was passing a church when she was grabbed from behind, thrown to the ground. The victim told police that she was SA'd, okay? This is just the beginning. You will not believe, I promise you, you will not believe the next things that I'm about to read to you. She started screaming and elbowed this roach in the face. He ran off in the direction of Bushnell Park, where he was chased and tackled by two of the victim's co-workers, including an environmental conservation officer, a fellow employee said. One of them held him down until police arrived, according to the incident report. You know, had they killed him while holding him down, you know, they'd be prosecuted to the fullest. Now, Oakes gave him a different account of the incident. So this felon, who was on probation when he committed the crime, gives a different account. And listen to this. They are going to believe him. It's that insane. He told police that he noticed a beautiful woman walking by while he was sitting outside the lab and heard voices in his head telling him to grab her. According to the incident report, Oakes said he squeezed her buttocks and took off running when she yelled. The victim, who was distraught and visibly shaken up, was taken to St. Francis Hospital for medical treatment. Now, listen to this. Okay, wait. The State Department of Energy and Environmental Protection sent a letter to its employees Tuesday in its wake of the incident, informing them what had transpired and offered security escorts and employees to the parking lots. In the meantime, continue to be cautious concerning your surroundings and report any suspicious activity. Shut the F up. Shut up. You know, I hated the HR and these stupid reports, but that's not what I'm talking about. What pisses me off. I'm just saying, or law. Like, you know, it's 2:00 in the afternoon. Is that really the world that we've come to? You got to. Now it's her fault that this happened to her, isn't it? But listen to Connecticut, that leads believe all victims. Listen to what the DA says. Hartford Police and Department of Administrative Services, which is responsible security headquarters and state employees of parking lots, are conducting a separate investigation. Now listen to this. So he has an extensive criminal history spanning several towns. Born in 1987, he showed convictions out of New Britain, Enfield, and Manchester. He has 3 convictions when he commits this crime. So what happens? What does the DA do? The strong, brave DA that's meant to protect their constituency from a 3-billed offender who was on probation when he committed this brazen essay in broad daylight. He offers a deal that the judge says no to. The judge rejected the plea agreement. Listen to this. The judge Thursday rejected an agreement that would have let this man, who was accused of essaying a state employee in August, plead guilty to a reduced charge of unlawful restraint. Yes, unlawful restraint with a sentence of 2 years and a day in prison plus 3 years special parole. This is what the DA offered a repeat felon who essayed a state employee. You cannot make this stuff up. This is why we do this channel. This is the very reason these two-faced, agenda-driven, psychopathic DAs that are put in charge to protect us, hell no. They are put here to create havoc amongst us. There is no other excuse. Look at the details. Look at what he says for it. Alan Oaks, 27, who was charged of attacking a 20-year-old woman on August 11th, 2014, as she was headed from the office. 2 people who heard the victim's screams chased him down. Okay. He was charged with first-degree essay and second-degree breach of peace, but after the attack occurred near I'm sorry, just some redundancy. Okay. Prosecutor Thomas Garcia. I would love to see Mr. Thomas Garcia, what his record of prosecution is. This is the stuff that you need to call out. This is the stuff that needs to be covered. Who is this man, Thomas Garcia? He told Judge Joan K. Alexander on Thursday that there is no evidence that SA occurred. This is not the defense attorney. This is the prosecutor. The prosecutor is pleading to the judge on behalf of the repeat felon. And that the only DNA found on the victim was her own. You just can't make it up. He is literally playing defense for a repeat felon, and we're seeing who this exact felon is, who this monster is, who this psychopathic, unhinged, sadistic beast is, and you have a DA fighting on his behalf. You can't make it up. And by the way, anyone who doesn't want to hear me rage, just go to the description, click the timestamps. I should have told you this 9 minutes ago. You can skip to the next hearing, but I think this context is so important. That's why I'm doing it now and not at the end, just so you can understand how insane of a system it is that we are in. Now, Garcia, and this is not it, by the way. This is just the beginning. Garcia said he also found credible Oaks' video recorded statement in which she admits attacking the woman from behind, but insists he did not penetrate her. So they are trusting a repeat psychopathic felon who was high on K2, his record of events, versus the woman, because any woman wants to admit that they were essayed, and right, that they want the public to know that she would make that up. It's asinine. He seemed credible in terms of acknowledging he accosted her and grabbed her backside, the DA told the judge, but there is also a question of whether he could have formed the intent to commit the crime. He said, I just can't. I can't. Alexandra appeared willing to accept the agreement until she asked about Oaks' criminal record. So the judge was going to accept it. She asked about his criminal record, which consisted of several convictions, larceny and burglary. She said that she understood the lack of forensic evidence to support the SA charge, but that she could not accept the agreement because of Oaks' criminal record. She put the case on the pretrial list for Oaks and due back in February 26th. Thank God for this judge. How many times have we seen like a Judge Boyd or a judge, was it Irwin? What's his name? who like laid down the law. I can see this as a Judge Boyd moment. No, we're taking this to trial. She's fighting the DA, which is again the insane part. And of course he SA'd her. You don't make that stuff up. You know, sometimes DNA it doesn't stick, or maybe he had something on him. You know, like you just that like maybe he was. It's like there are other explanations into I believe the guy in K2. No, you believe the bloody victim. No one makes that crap up in this. No one that in this scenario. You gotta be nuts. Oakes was on parole and living in a halfway house in Collins Street at the time of the attack. Told police he went to catch a bus while he was smoking K2. According to the police report, after the K2, he told police he decided not to get on the bus, but instead to wander around town. Oakes told officers that he sat on the steps and watched people walk by. According to the report, 10 minutes later, he said that he saw a woman walking past him and he stood up and started to follow her. He said that once he started to follow her, he heard voices in his head telling him to grab her. According to the report, he then grabbed her from behind on the inner thigh. Now, while he ends up getting sentenced, so he ends up getting sentenced to really a puny sentence. Remember, he's a multi-bill offender at this point with arrests in 3 different counties or whatever in Connecticut. He gets SA 3rd degree. They give him a 5-year sentence. Okay? 5 years. Now, while he is locked up, he essays a correction officer. This is the same year, June 15, 2025. A Hartford man charged with 3rd-degree essay assault and 2nd-degree unlawful restraint of assault of a public safety officer. The incident took place. So this incident took place at McDougal Walker Correctional Institute in the morning of July 10th when Oakes allegedly reached down the officer's shirt and grabbed her breasts, according to the affidavit. I wonder if they should believe her. They should believe him. His count of the reports is probably more accurate. Now, this is all that's here. But did they sentence him to more time for this? No. No. He didn't get sentenced to more time for this. It was a freebie. It was a free grab. Just go for it. Just have your way with the COs. You know, why not? So now let's move forward. They parole him in 2022, or he gets out, I guess, after. So I don't know if they actually had a parole hearing, but he gets out and now he has special parole. And what's he do? What's he do when he's out on special parole? He starts stalking his boss. And remember, this again is not why we are here today. We are still leading up to why we are here today. Oh, I love how they have this big popping thing in my face. Whoever wants to see that. On June 28th, a man convicted of SA is accused of stalking a coworker days after starting a new job in East Hartford. The man, Alan Oakes, was charged Friday with electronic stalking, 2nd-degree harassment. He's being held in $10,000 bond. The affidavit supporting Oakes' arrest provides the following details. On June 20th, a woman called police to report that she was concerned for her safety regarding a coworker. Oakes began working at the company on June 13th, and she was tasked with training him. Can you imagine being tasked with training this monster? And then think about this again. This is not why we're here. When he was out on special parole again, they set him up with another employer, another job. Who does that? Now, the woman said that on June 17th, Oakes left a sticky note in her locker with his phone number, and she messaged him to be friendly. She messaged him to be friendly. That's the biggest mistake. And it's not her fault. The world in which we can be friendly and nice, it doesn't exist anymore because of DAs and judges like this. Now, she said that their conversations were mostly normal until Sunday. At one point that day, Oakes asked where she was, and she responded that she wasn't home, when in reality she was. Oakes replied in a way that suggested that he knew she was home, the woman told police. Once back at work Monday, June 20th, her boss informed her about Oakes' past criminal convictions, which concerned her, which it should have. Later that day, she told Oakes that she no longer wanted to talk to him outside of work, which made him angry. Oakes' parole officer confiscated his cell phone and found that Oakes had downloaded tracking applications. When asked if he had used the app to track the woman, Oakes said he had because he needed to know if he could trust her. Okay. Oakes admitted that he began tracking the woman the day before using her phone number. His phone showed a history of Google search for now, how to secretly track a cell phone location, and another search for information on the woman made 3 days after he started working. The woman further reported that Oaks sent her a friend request on Facebook the day after he quit, which she denied. She blocked all his accounts as well. Oaks then made another account and attempted to contact her again. Okay, so that was 2022. Now again, he ends up serving. He ends up for this. They give him a 731-day sentence for this. Special parole 30 months. And then they also give him an unconditional discharge. Well, and he also then gets out in 2024. And he violates again. He fails to register, which he gets a 1-year jail suspended. So they don't even give him any sentence for this. Like as if they could have, and then they don't, right? Now, while he's out, he gets a new job. And as you heard, he cuts off his ankle bracelet, and he's stalking his manager at the job he gets. We're going to find out now, he's coming back in for his next revocation hearing, that from the time that we just saw him in the 2 weeks period to the time we saw him now, he has not stopped contacting her. He's been calling her and sending her letters while in jail. And yet, he's not in a red jumpsuit. He's not handcuffed. He's not in the hole. He's not punished at all. The DA is not bringing new charges. No, he's only facing revocation. No new felonies, nothing. You can't make it up, guys. So let's jump in and watch this insanity.
Alan Oaks, 325582.
And we have a parole officer present. Can you please identify yourself for the record?
Parole Officer DeWilder, Hartford Special Management Unit.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is at least you place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge. The state, your PO is bringing against you. I will review and identify exhibit file for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I do not.
Okay, you have important rights today. You have the right to have an attorney present. Would you like to continue without an attorney?
Correct, yes.
Okay. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Correct, yes.
Okay, you have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, so we'll now review the charge. The state your parole officer is bringing against you, and the information underlying each charge. I'll just note, charge 3 is not taken into consideration as a no finding was made at the time of the preliminary hearing. So PO DeWilder, can you please read the other charges?
Yes, under release direction, charge number 1, GPS. On 8/16/2024, you failed to charge your GPS unit as required, resulting in a battery shutdown beginning at 4:33 p.m. and ending 8/17/2024 at 5:51 a.m. For approximately 12 hours, your whereabouts in the community were unknown. On 9/7/2024, you failed to charge your GPS unit as required, resulting in an approximate 3-hour shutdown from 12:27 p.m. to 3:34 p.m. Your whereabouts in the community were unknown at this time. On 9/8/2024, you failed to charge your GPS unit as required, resulting in an approximate 2-hour shutdown from 3:51 a.m. to 5:36 a.m. Your whereabouts in the community were unknown at this time. On 7/4/2025, you failed to charge your GPS unit as required, resulting in a shutdown from 3:29 a.m. to 10:05 a.m. Your whereabouts were unknown during this time. On 11/16/2025, you purposely cut the strap to your GPS unit at approximately 7:17 p.m. and removed it from your ankle. You left the GPS unit in the basement of the halfway house. Charge number 2, program participation. You were unsuccessfully discharged from the CTPSB sex offender treatment due to continued display of high-risk behaviors, stalking, harassing, that mirror previous behaviors. Charge number 4, absconder. On 11/16/2025, after cutting your GPS unit strap, you intentionally walked out of your residence at approximately 7:17 p.m. At no point did you attempt to contact your supervising officer as you evaded your parole supervision. Your whereabouts were entirely unknown until you were located at Bradley International Airport by Connecticut State Police Troop W on 11/19/2025. Charge number 5, halfway house placement. On 8/6/2024, you were on a work pass from the halfway house and were due back by 5:22 a.m. You admitted that you had deviated from the pass and went to the airport, which is a misuse of the pass system as you are permitted only to go to and from your employer. On 4/1/2025, you were issued a pass to accurate staffing from 10 a.m. to 1 p.m. and stated that you were there. A review of your GPS monitoring indicates that you never reported to the destination. This is a misuse of the pass system. On 6/16/2025, halfway house staff witnessed you smoking a marijuana joint on smoke break, which you admitted to. A search of your space yielded you to be in possession of marijuana. These actions violate the halfway house agreement as you are not to consume or possess marijuana in a halfway house. On 7/4/2025, you were directed by your supervising officer that you are not to get in a car with anyone other than an approved driver, as you are aware in your halfway house agreement. A review of your GPS monitoring indicates that you were in a car on 7/4/2025, 7/6/2025, and 7/7/2025. At no time did you propose anyone to drive you, nor was anyone given permission to be an approved or authorized driver. On 7/8/2025, you admitted that you knowingly violated this rule and received rides home from work. On 9/7/2025, when you returned to the halfway house from a work pass, you are in possession of marijuana. At no time are you to consume or possess marijuana at a halfway house. On 11/14/2025, you were issued a common pass to attend religious services. At no time did you go to your destination, which you admitted to. This is a misuse of the pass system. Charge number 6, enhanced internet and device monitoring. On 6/24/2024, you were found to be in possession of an unmonitored cell phone. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Sexual Behavior that you were using the computer at the halfway house, which is unmonitored. On 10/29/2025, you were found to be using an unmonitored computer at the halfway house. You knowingly use this unmonitored device to access prohibited sites and material to evade parole. Charge number 7, problem behavior treatment. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Behavior that you had been frequenting a dating website. Per your treatment agreement with the connection, you are not to access any dating sites without prior permission. On 9/12/2024, a review of your IPPC, which is the Enhanced Internet and Device Monitoring System, was conducted. Supervising officer reviewed 374 pages of keystrokes. A significant number of these keystrokes were through the various end-to-end encrypted applications, including, but not limited to, Caption Call, Text Me Up, WhatsApp, Telos, CloudSIM, Bombard, Inocupation, iPlum, OpenPhone, BIP, Ring4, and Duo. In these applications, you are attempting to message, call, and or text random telephone numbers in sequential order. In many of these messages, you are identifying yourself as Brittany, attempting to make contact with a female. You admitted that you were hoping to get an answer and you can't stop as you are trying to satisfy your sexual needs. Excerpts from numerous randomly attempted contacts include, "Hey, sorry to wake you. It's Brittany. Let me taste you. I'm so I want to play with you. I'll pay you. You were soliciting sexual acts and offering to pay between $50 to upwards of $350. In addition, you inputted the following: young sex, young girl kid, young girl penis, 7-year-old girl tits, little girl ass. You also used a web image downloader to create stimulating pictures of children that you saved to your phone. On 10/29/2025, you reported that you have been using an unmonitored computer at the halfway house. You provided your supervising officer your login and your history was reviewed. Per your CTPSB agreement, you are not to be communicating on social media or chat sites. You created a Reddit profile with the name Ladder Cookie. You made at least 3 thread posts to include one stating, "A man who loves to spread his hello, I'm in love with pegging my with toys, fingers, hands, whatever." You also viewed and reposted 2 videos. My boyfriend had fun with Molly Little and play with both tight holes. At no time are you to view simming material on any electronic device. In addition, you are searching various platforms for your former supervisor. When questioned about this, you stated you wanted to learn more about her. You are not permitted to access social media platforms per your CTPSB agreement. And on 11/20/2025, the Center for the Treatment of Problem Sexual Behavior unsuccessfully discharged you from the treatment based on continued high-risk behavior that mirror your previous offenses.
Thank you. Can you also read the 2 addendums that were submitted?
I can. The first was submitted on January 22nd, 2026. On 1/22/2026, supervising officer received notification that Oakes recently sent his former boss, victim, 2 letters. One was postmarked 12/22/2025, and the other was dated 1/15/2026. Despite being directed to not have contact with her, Oakes continues to obsess with the delusions and makes attempts to contact her. The second addendum was submitted yesterday, 1/29/2026. On 1/29/2026, supervising officer received notification that Oakes sent another letter to 5 guys dated 2/17/2026. 1/17/2026, that's an error. Oakes is also contacting 5 guys directly via telephone. And yesterday on 1/29/2026, he attempted calling there at 2:14 p.m., 2:20 p.m., and 2:22 p.m. Oakes' behavior is escalating even while he is incarcerated.
Thank you.
You're
And the
welcome.
state has filed the following exhibits that were noted A through L at the time of the preliminary hearing. And additional, that exhibit that was submitted is, I am labeling Exhibit M, which are pictures of letters sent to GC 12/22, 1/15, and 1/11 dated. Did you receive notice of pro violation for in the items that I labeled A through L, sir, last time at the prelim?
Yes,
And M, as I stated, I know you did not receive that yet, but you wish to continue with the hearing.
correct, yes.
Okay. So we have no witnesses at this time. At this time, I'm going to swear in you, Mr. Oakes, as well as Peter Weiler, in the event that you would like to speak today. So can you please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God, or by penalty of perjury?
Yes, I do.
I do.
Okay, so at this time, the state will have an opportunity, if you'd like to present evidence, to speak to any of the evidence submitted at this time, you may.
I just want to say that the behaviors that Mr. Oakes exhibited while in supervision, as illustrated by all these charges, show that he is someone who continues to defy his stipulations. He was in a high-risk sex offender treatment group and was not permitted to use a computer other than for work purposes. Yet he knowingly used an unmonitored computer to satisfy his preoccupations with his coworker and needs by creating a profile on Reddit. Ultimately, Oakes decided to cut his GPS bracelet and abscond from the halfway house, and the first place he went to was his former employer, 5 Guys. The combination of all charges in this PVR and his escalating high-risk behavior are of great concern to Parole.
Thank you. Okay, now is your opportunity to respond to parole violation charges against you, or remember that you may remain silent if you so choose. Would you like to respond to the charges, sir?
Sure, yes.
Go ahead.
I would also agree that my behavior is escalating, and it's unfortunate when there's just no closure. Am I obsessed? No, it's not that. I just feel like maybe I have been pushed out of a job that I so liked because of my crimes that I have committed. I don't think I'm delusional. It has nothing to do with that. I'm not obsessed. I just feel like there was some foul play. And yes, that may be my mind going in that direction. But it's hard to sit here and wonder when I did so well at a job that I loved. And the moment that this woman becomes the general manager of the place, within weeks, I am found. When we had women work there the whole entire time. So it ain't the women aspect, it ain't me dating. It has nothing to do with that. I feel like I have been robbed out of my opportunity to create a better life for me in that workplace because of the charges that I've had against me. With that, I end.
All right, thank you. If you want to wave your hands just so the light comes back on, because you're sitting in the dark. I don't want you there.
Sorry.
Thank you. That's okay. Thank you. I'm just noting what you've stated. All right, so I have noted what was stated. So what I'm gonna do next is I'm gonna announce my findings in regards to the charge. If either side doesn't have anything else to say at this point, no, okay. So regarding charge 1, I do find you violate condition GPS based on evidence provided in support of that charge, which is exhibits B, F, and G, as well as testimony that was provided at the preliminary hearing. Regarding charge 2, I do find you violate condition program participation based on evidence provided, exhibits B, E, G, and H, as well as testimony that was provided at the time of the prelim. Regarding charge 3, that was not taken into consideration as no finding was made at the time of the preliminary hearing and no new evidence was submitted regarding that charge. Regarding charge 4, find you violate condition absconder based on evidence provided, exhibits B and G, as well as testimony provided at the preliminary hearing. Regarding charge 5, I do find you violate condition halfway house placement based on evidence provided in support of that charge, exhibit B, F, and G, as well as testimony provided at the prelim. Regarding charge 6, I do find you violate condition enhanced internet and device monitoring based on evidence provided, exhibits B, E, and G, as well as testimony provided at the preliminary hearing. Regarding charge 7, I find you violate condition problem sexual behavior treatment based on evidence that was provided in support of that charge, which is exhibits B, E, H, I, and G, as well as testimony provided at the time of the preliminary hearing. That includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So at this time, Peter Violet, would you like to say anything else in regards to that part of the hearing?
I would.
Okay.
I would like to note that this is the third time I have participated in a revocation hearing for Oaks in the matter of less than 3 years. One violation was criminal, and he was incarcerated for over a year for harassing a coworker. Oaks completes his special parole sentence in November of this year with no supervision to follow. Some argue that providing some time on community supervision prior to EOS is beneficial, but I believe Oaks is the exception. Giving him any ability to gain employment under supervision would only be allowing him to create more victims. Once he's established his delusions in a workplace, whether within a mere 7 days or a couple months, he himself has admitted he can't stop. Oaks is unable to understand boundaries, whether it be with halfway house staff, therapists, coworkers. Releasing him early and providing a safety net would honestly just be setting him up for victim access. Despite inpatient treatment and multiple bouts of incarceration for the same behaviors, Oakes is not changing for the better. He's only becoming increasingly more high risk, even with supervision. In fact, as noted in my recommendation, most of his offenses have occurred on supervision or while he's been incarcerated. He was even directed by police to seek contact with the victim at Five Guys, yet while awaiting this revocation hearing, as submitted in the addendum, Oakes continues to reach out to her with cryptic letters. As recent of yesterday, Oakes was calling Five Guys incessantly. His behaviors are not conducive to the safety of our community. I strongly support a full revocation of parole based on his demonstrated inability to control himself. Thank you.
Thank you. All right, Mr. Oakes, would you like to make any statements now regarding future plans to go back into the community, things you've been working on, anything like that? Now would be the time to do that.
No, I'll continue to work on myself while I'm here, because I too also think that it would be best if I stayed here until my EOS date.
Do you have a sponsor? Or, I mean, do you have somewhere to go when you discharge?
I do not. Which makes it all the more scary.
So I'm saying you wouldn't need housing in what area?
Not Hartford.
So what does not Hartford mean? New Haven, Waterbury, Bridgeport?
I would have to go to Hartford, but that's... Do I have to make this now?
This is just this information that I'd give to the parole board, because I have to present your case to the parole board. If you don't want to tell me anything and you don't have anything to say, then you don't have to. No, I'm just asking you as what your plan would be.
I have no plan.
You think that's something you should work on while you're in there?
I've been working on it, but you know.
What have you worked on?
I'd rather not say it. It doesn't help me in any way. It doesn't help me. It doesn't help me in any way.
Okay. So I'm gonna put a few things on the record, and then I'm gonna make my recommendation. You were in the community approximately a year and 6 months before you were returned to custody. As was stated, you have prior violations, which include a criminal violation, which you received a new parole eligible sentence for the same behavior as described as your offense today. You did receive 10 misconducts, as well as received additional evidence of you submitting letters to the person that is considered a victim that you were not supposed to have contact with while you've been incarcerated, and calling the place that she works at up until yesterday. So that is new information that we did receive. Based on today's hearing and evidence and testimony, I will recommend parole be revoked, remain incarcerated until your special parole completion date of 11/13 of 2026, which is an approximate 1-year sanction. I will present this to the parole board on February 13th. You will receive official written decision from the board about a week after February 13th. You'll get their decision. So if the board decides they would like to parole you prior, they can, and you'll be notified of that. It'll be in the disposition that you'll receive from us a week after February 13th. Do you have any questions?
I do not.
Okay, so then you are all set for today, sir. Thank you, Theo DeViler. This hearing has been concluded then. Good luck, sir.
Thank you.
Now, normally I would have waited until February 13th to see what the parole board does on their final review and include it in this hearing, but I'm going to be traveling for my day job, and I won't be able to get it done until maybe 10 days after the 13th. So I just wanted to get this out to you guys now. I don't think they're going to reverse the decision. They're going to say, no. Let's make it 6 months so we can have special parole. Now, if they do, if they make any other decision than just agree with the interviewer's recommendation. I will bring this hearing back and we will discuss that. Now, if they do, they will have what's called a supplemental hearing. It's a whole nother hearing where the board interviews them. It will be in the return of playlist. Anyways, I fully expect this hearing to get fully demonetized. So sometimes it's good to, on a second time, look at lawyer got demonetized and edit it up, tighten it up, and hope for a second go anyways. But that's just why I'm bringing it to you now. Now, did any of you catch there when he said, I am working on something, but I better not bring it up? In his mind, what I believe is that he is working on getting this manager at the Five Guys to send to admit her love for him and to like write a letter and get like he's probably working on something like that, and that's why he said he doesn't want to tell them. It won't help him. I mean, how insane. If you guys want to say hi to Coco. How insane. I told you, I'm not exaggerating this case, just how insane it is. I wonder why he was at the airport. Do you think she went to the airport and he followed her there? Or do you think he was thinking of absconding? I don't think he was thinking of absconding. I'm more concerned she was probably so terrified for her life that she had to get on a plane and fly out of here. That would be my guess. And he followed her there. I think it is that crazy. And then the idea that he is writing letters and calling her up until yesterday, and the prison won't. They have that on record, and he's not in a red jumpsuit. He's not in the hole. What? I know that there are COs that watch this from these very prisons. I get DM'd by them. If you're watching this, please let me know why. Please let me know why it is that he is not in the hole for doing this. And then you have to say, whoever would be under their jurisdiction. I don't know if it's the state police or whatnot, but why is he not being slapped with charges for that? It's on the record. What's taking you guys so long? And it's because it's Connecticut. I mean, you couldn't believe what we first went over is that he had a DA pleading for his case to the judge as if he was the defense attorney, saying, oh, there's no proof that he SA'd her. I know she said that he SA'd her in broad daylight, but he just slapped her butt. So, just give him and you look at his actual record. And even with the crimes that they end up charging them with, it does not represent the monster that he is. How dangerous and delusional and psychopathic is this beast that needs to be locked up, frankly, for his entire life? He has the SA third degree, which is not, by the way, Connecticut wipes out records when it's more than 10 years old. Sir Richard would have grabbed this. Thanks, Sir Richard, by the way, here for doing all the research before, because today, if you look this up, it won't even show these offenses because Connecticut expunges records from the public every 10 years because they are protecting the felon. That is their doctrine. This was a harassment second degree. I don't even know what this one is. If this is, I'm not even 100% sure if this is what they dropped it down to harassment when he SA'd the CO. He has stalking and harassment, failure to register, and then there are no new charges that we have. At least maybe he is being charged, but I don't know for the stalking. It's not really. They just say it was a criminal violation, but I don't see anything. There's no pending cases that I'm aware of, right? Are there? The only saving grace, although it would have been entertaining as hell, is if he had taken a free attorney that's appointed him. He didn't take the free attorney. I would love to have known how an attorney would have defended this. I mean, we've seen the attorneys; they have no shame. They will say and do anything. But I would have just loved to have seen. I would have loved to have seen Manigletti see how he would have tried to. Oh, my client, he didn't do anything. He just got a new job and he got let go. He was just being friendly to the manager. You even hear what he said? He's like, this isn't. He's like, This isn't my fault. I had a job. This was finally my favorite job. What was his words? It's unfortunate when there's no closure. I'm not obsessed. I feel like I've been robbed of my job opportunity. Everything was working out, and then when she became a manager, it all went bad for me. And then I guess the scariest part of all of this is that he is getting out November 13th of 2026. That's that's like right around the corner. It's like right there. When we blink, it's going to be November of 2026. And he's going to get out. He's not going to be on special parole. He's not going to be under supervision. And he is going to create more victims. And this is the district attorney's fault. The blood is on his hands. It's the Connecticut's fault. It's the system's fault to think that he would do this to a state employee. How do you get, at that time, as a repeat felon, a 5-year sentence? While in prison, essay a guard, not get additional years for it, and then have violation after violation after violation, and not be given a long, healthy sentence to keep the public safe, is nothing short. You use the words insanity, but it's more than that in this case. It feels criminal. It really feels criminal. The next victim, the mother, the father of that victim, you will look at this case and you will just say, how is it possible? How are those put in charge to protect us so negligent? So wantonly negligent, blind. There's no answer to it. We don't have PhDs. We don't understand these things. I know I'm just saying what everyone else is thinking. Every parole hearing we have some nut job who writes in the comment section, "Oh, sex offenders have the lowest rate of reoffending. Oh, there's no risk here. Oh, it's fi-" I don't think anyone can watch this. Not even trolls control this. This is just insane. I hope this, I'll predict this right now. This is an easy prediction. He is going to create a new victim when he gets out, probably within weeks of getting out. It's going to be on the news. And I will do my best. I will do my absolute best to get in touch with whatever news agency it is to let them know that this exists so that they have a record of it. And maybe this can go, you know, starting with the DA, if he's still in office. I haven't looked it up. It just needs to start there. But there you go. I mean, normally I'd be really ranting and raving, but holding cocoa is something very therapeutic about it. Calms you down. It keeps you sane. Ladies and gentlemen, we live in a messed up world. And with that, I'll let you go.
Some argue that providing some time on community supervision prior to EOS is beneficial, but I believe Oakes is the exception. Giving him any ability to gain employment under supervision would only be allowing him to create more victims. Once he's established his delusions in a workplace, whether within a mere 7 days or a couple months, he himself has admitted he can't stop. Oakes is unable to understand boundaries, whether it be with halfway house staff, therapists, coworkers. Releasing him early and providing a safety net would honestly just be setting him up for victim access. Despite inpatient treatment and multiple bouts of incarceration for the same behaviors, Oakes is not changing for the better. He's only becoming increasingly more high risk, even with supervision.